I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand your right to a lawyer, including a court-appointed lawyer?
I understand that.
Okay. And do you wish to represent yourself instead of having an attorney?
Yeah, I'm here.
We've got a defendant trying to represent himself, and the judge is doing the one thing the court must do first: make sure this guy actually understands what he's risking. The stakes? Up to 3 years and fines, plus multiple charges. But watch closely. He's not answering the judge's basic questions. He's trying to detour into jurisdiction arguments and legal buzzwords. And when that happens, courts don't play along for long. So the big question is he asserting rights or using confusion as a strategy? Because in about 2 minutes, this turns from paperwork to handcuffs.
By special appearance, and I will be representing myself.
Okay. I'm required by law, before I accept that waiver, to do a couple things. One, advise you of the maximum penalties that you could face for the charges that you're in my court for. Resisting, obstructing conservation officers is a high court misdemeanor punishable by up to 2 years in prison and or $1,000 fine. There's a habitual offender second notice that's been filed by the prosecutor, which would make that a felony punishable by up to 3 years and or $1,000 fine. And marine safety operating while intoxicated is a misdemeanor punishable by up to 93 days and or a $100 to $500 term. Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here, honestly.
Well, okay. Well, that's fine. Do you understand the maximum penalty that I just explained to you?
No.
Hold on, I can't let you represent yourself until I establish a couple things.
Well, I need to establish a couple things too, honestly.
Hold on, well, I can't let you represent yourself until I establish a couple things, or I'm going to be in trouble.
Okay.
Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or a $1,000 fine?
I don't understand the nature and cause of the action against me. So
what is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
The nature and cause of the action against me because we don't establish jurisdiction.
That's not what I'm asking you right now. Well, I'll let you place whatever objections you want on the record, Mr. McLeod. I promise you that. Okay. Can we just go one step at a time? So do you understand the maximum penalty that you could face if you're convicted as charged? 3 years in prison or $1,000 fine?
Well, I have another question because the statutory jurisdiction doesn't exist under the Constitution. So in order for me to defend myself, could you please tell me where the published rules of conduct are for criminal statutory jurisdiction, or where I can find the nature and cause of this jurisdiction, or how this information exists?
No, I don't even understand what you're asking.
So you're saying this is a statutory jurisdiction under what? The statutes of Michigan, correct?
Mr. McLeod, I've told you what my jurisdiction is.
General jurisdiction.
The people of the state of Michigan voted.
This is exactly why judges do the waiver of counsel check like a checklist. If you represent yourself, the court has to be confident you're knowingly giving up a lawyer, because if you don't understand the charges or penalties, it can blow up the entire case later on appeal. And notice what the judge keeps doing. He's not debating philosophy. He's asking a simple competency question. Do you understand the maximum penalty? Meanwhile, the defendant is dodging into "I don't understand jurisdiction" territory. That's a common sovereign citizen-style move. Flood the record with buzzwords, demand proof of jurisdiction, and avoid answering direct questions. But the courtroom runs on procedure, not internet legal theories. So here's the audience question. If someone won't answer basic yes-no questions, should they be allowed to represent themselves at all?
To convene a constitutional convention in 1961.
Sure.
There was a constitutional convention in 1961 and 1962. They proposed a state constitution. The voters of the state of Michigan ratified that in 1963. Article 6 establishes the judicial power. And the circuit court is a court under that judicial power of Article 6 of the state constitution. And so you're here in my court. I have subject matter jurisdiction over those crimes. I have personal jurisdiction over you because you've been alleged to have committed them in our county. That's my jurisdiction. So, Mr. McLeod, you want to represent yourself? Do you understand the maximum penalty that you could face of 3 years in prison and or $1,000 fine?
1 second.
I can see why his attorney withdrew. Oh, shit.
Hang on, someone in the prosecutor's office is not muted. I'm going to remove you from the meeting at this time.
Oh,
Prosecutor's office is generally allowed to attend to observe. They've participated. I'm removing them from the hearing. Mr. McLeod, do you understand the maximum penalty that you could face?
1 second. Okay, so when enforcement of mere statutes, judges of all courts do not act judicially and are thus are not protected and qualified by limited immunity. That's Owen versus the city. I just want to state a few things for the record since you're claiming this is a jurisdiction under statutory law.
Hang on. Mr. McLeod, can we back it? Look at me for a second. Can we talk here?
I've challenged subject matter jurisdiction and nothing can go forward until that's addressed. You're saying
I did address it and I denied your objection. I have subject matter jurisdiction.
Doesn't exist under the Constitution.
Your objection is noted. So, Mr. McLeod, do you understand? Let me explain to you.
Sure.
Sometimes, as I said, people might want to represent themselves, but let's say they have limited intellectual capacity and they don't understand what's going on. I have to establish that they know what's going on before I can allow them to represent themselves. I'm required to establish, do you comprehend, do you know the maximum penalty that you could face if you're convicted as a result of this charge? 3 years in prison or $1,000 fine. Do you understand that, Mr. McLeod?
So I'd like to state for the record that
Mr. McLeod, stop.
the court can be
Stop, Mr. McLeod. If you don't understand it, I'm going to revoke your right to represent yourself and have an attorney represent you because I can't establish that you know what you're doing. So do you know the maximum penalty that you would face?
Your Honor, I've challenged this court's jurisdiction. You haven't established it yet. You said you have a statutory jurisdiction which doesn't exist under the Constitution. I'm trying to figure out where I stand with this. So I can't answer any of your questions until you answer some of mine.
That's not how it works. Are you refusing to answer my question?
No, I'm
Then answer it. Do you understand the maximum penalty that you face for this charge?
So judges who become involved in enforcement of
Mr. McLeod, I have other matters. Mr. McLeod.
This section is the court drawing a bright line between real jurisdiction and performative objections. The judge explains it plainly. The state constitution sets up the courts, the circuit court has authority over these crimes, and personal jurisdiction comes from the allegation that the acts happened in the county. That's how courts operate. Subject matter jurisdiction is about the court's legal power over the type of case, and personal jurisdiction is about authority over the person. The defendant's statutory jurisdiction doesn't exist argument isn't engaging with the judge's explanation at all. It's like answering, what's 2 + 2 with, I reject math. And that matters because the judge's next step is procedural. Either you show you understand the risks or you lose the right to represent yourself. So pause and think. Is the defendant confused or trying to force a script the court refuses to follow?
You know, I understand you want to object to things, and you're going to be allowed to object to things, okay? Sure. But we have to do things one step at a time. And I do have other cases today. I'm not going to entertain this for like a whole hour. I've got other cases going on. If you want to dig in your heels and just make this real complicated or real difficult, we could do that. And I can hold you in contempt and you'll go back to a jail cell for a while.
I don't wish to be held in contempt. I just wish to exercise my Sixth Amendment right.
That's fine.
And
so before I can let you under,
I can cite laws that will show you that the exercise of a right can be converted into a crime. I'm trying to understand the nature and cause of the action against me. You're not clarifying enough to where I can comprehend it, as you say.
You don't comprehend the maximum penalty that you would face.
I'm not answering any of those questions until you establish that this is a court of the Constitution, has jurisdiction under these jurisdictions.
I established it. I told you. You might think I'm wrong, and you can appeal.
There's no such thing as a statutory jurisdiction.
Mr. McLeod, let me make this simple to you. Do you ever watch Let me make this simple for you.
Sure.
I'm going to ask you this question one more time. One more time.
Okay.
Two things are going to happen. You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. You understand that?
So,
Mr. McLeod,
contempt for what?
Mr. McLeod, two things are going to happen. You're going to answer my question, or you're going to jail for summary contempt for not complying with the court's request. Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court, taken into custody.
Really? That's it. Protecting my rights is what you said last time. Sorry.
Fucking Joe.
This isn't true. You guys are
Follow
following
unconstitutional
You're following
orders.
unlawful orders. It's not
Not a
constitutional at all.
thing.
Mr. McLeod's in contempt, he's sentenced to 1 day. Mr. McLeod, your sentence is 1 day in jail. We'll reconvene tomorrow and get you
This is about
notice.
the Constitution. I did nothing wrong except to question and exercise my rights.
Here's the professional wrap-up. This hearing isn't about deciding guilt yet. It's about court control, procedure, and whether the defendant can knowingly waive counsel. The judge repeatedly tries to confirm one basic requirement. Does the defendant understand the maximum penalties attached to these charges, including the enhancement risk mentioned earlier? The defendant refuses to engage with that narrow question and keeps pivoting to jurisdiction objections, even after the judge explains the constitutional basis for the court's authority and notes the objection for the record. Once the defendant won't comply with the court's direct order, the judge moves to summary contempt, a short, immediate sanction to restore order and move the docket. The broader implication is simple. Rights exist, but courts can require you to follow process to exercise them. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.